Welcome to Constangy Clips, the series with tips on staying ahead of important legal challenges in the workplace and cyberspace. My name is Sonita Thompson, and I'm an attorney in Constangy's Jacksonville office. As social media use continues to grow, employers are increasingly faced with difficult questions about where an employee's personal life ends and where workplace concerns begin. Today, I'm going to share 4 practical tips for managing employees' off-duty social media conduct. First, know your legal boundaries. Your legal boundaries may differ depending on the type of employer you are. Private employers generally have broad authority to discipline employees for off-duty social media conduct. Public employers may face more constraints, including the First Amendment to the U.S. Constitution. Under the National Labor Relations Act, private employers are prohibited from taking action against employees for engaging in what is called protected concerted activity. That's when an employee addresses terms and conditions of employment with other employees or on behalf of other employees, regardless of the method of communication, in person, in print, online, or via social media. Terms and conditions of employment includes just about anything work-related, including wages, hours of work, and employer policies and practices. This restriction applies to both union and non-union employers. Understanding the laws that apply to your organization is critical. In addition to these, all employers should evaluate applicable state and local laws that may apply. Second, evaluate before you react. Before taking action, employers should evaluate the full context of the post, including the following. Was the post made on personal time using personal devices and a personal account? Did the employee identify themselves as working for your organization? Did the post reference the company, use a company logo, or involve coworkers? Could the content reasonably be interpreted as representing the employer's views? Or did the post threaten, harass, or target specific individuals? Context matters. 2 posts with similar content may create very different legal and operational concerns depending on the surrounding circumstances. Third, discipline should be tied to actual workplace impact. Employers who discipline employees based solely on the content or viewpoint of a post are more vulnerable to claims of discrimination and retaliation in violation of the labor laws and the right to free speech. The strongest basis for disciplinary action is demonstrable workplace impact. For example, did the post damage legitimate business interest or the public trust? Did it disclose confidential or proprietary information? Or was the conduct harassing or discriminatory towards coworkers, customers, or others? When discipline is imposed, employers should document the specific impact caused by the conduct and apply its policies consistently. Finally, have a social media policy that fits your organization. A well-drafted social media policy is one of the best tools for reducing legal risk. An effective policy should do the following: clearly define prohibited conduct, address both on-duty and off-duty conduct, recognize applicable legal protections, be updated regularly to keep pace with changes in technology and social media platforms, and be enforced consistently. A policy that is overly broad, vague, or not tailored to your organization may create legal exposure or be difficult to enforce. Employers should regularly review social media policies with employment counsel. When confronted with a questionable post, employers should avoid reacting impulsively. And when in doubt, involve employment counsel before taking disciplinary action. Thank you for watching. Be sure to follow Constangy on LinkedIn, Facebook, and YouTube for important updates and more tips for minimizing risk in this dynamic legal space.